Thank you, Piotr, for your interesting insight into a particular area of the application of the French law. I would like now to welcome Tomasz Krolasik from the University of Warsaw as well, who's a PhD student at the Faculty of Law and Administration, a graduate from the College of Interdisciplinary Humane and Social Studies of the university, has a Master Professionnel de Droit des Affaires, specialized in Droit Français and Européen des Affaires, from the University of Warsaw and University de Poitiers. And in his research, he's focused on 19th century French private law, French enforcement proceeding law in Poland, and constitutionalism. And today he'll speak about between the old and the new, problems of legal practice in Poland after enforcing the French Code de Procédure Civile during the Napoleonic Era. You do not have a PowerPoint?
Yeah,
No.
There's none. Yeah. Hello. First of all, I wanted to say that I have no PowerPoint presentation. I just decided that 2 PowerPoint presentation on Duchy of Warsaw, it would be too much for audience. So there is none. I will do my best to not to read my speech, but I can't guarantee any success. So first of all, my topic it's about Code de Procédure Civile, about French procedure code in Poland. It was enforced along with the Napoleonic Code just the same time. And why, in my opinion, it's important? It's important because the Duchy of Warsaw, of course, for most of you, it's unknown history of Poland, if the history of Poland is better known. It is quite relatively unknown. It is very short because it's only from 1807 till 1815, but so it means till the end of Napoleon in Europe. But on the other hand, it was 1813, so it's like nothing. It's 6-7 years. Why it's important? For us, it's important because this is the very first time when we had our own state, and at the same time, we were building a modern state. Modern state, it means that it was based on merits. We had a new system of the state. We have bureaucracy, we had administration, and of course, everything was taken, maybe not everything, but most of these things were taken from France. It was taken from France, but it wasn't. Some of these things were just given by France. The first speech was about different constitution in the Napoleonic era. Of course, in the Duchy of Warsaw, we had our own constitution. It was granted by Napoleon, and we say that, of course, we made it, but it was just written by Napoleon. The same thing was with 3 different but very important codes. It was the Napoleonic Code, it was French Code de Procédure Civile, and it was Commercial Code. It was just enforced along with the Napoleonic Code, and it was official that it has to be done. We couldn't decide if we want to have it or not. It was just made by Napoleon, but of course there were so many people who this is the difference between taking from France or taking from other countries, that this transition was made with the smile on the face, because everyone wanted it, and of course French was the most important foreign language in Poland back then, but only few people could use it. Okay, another thing is about this field of proceedings and enforcement proceedings. This is still introductions. I'm so sorry. Just to be sure, it's I understand that enforcement proceedings is not a very well-known thing even in contemporary law. Normally, civil procedure is better well-known, and that what I mean is there are like 3, 4, maybe 5 terms that I have to define for the first time. First of all, enforcement proceedings, it means execution of the court's rulings, like everything. Yeah, that's pretty obvious. Another thing is that it is made by official, called in English it's bailiff. In France, still it is huissier de justice. In Poland, it is komornik. So this is the same institution, the same position. So if I use bailiff, huissier de justice, or komornik, this is the same person. And another thing is that there is some kind of claim, special claim within this procedure. This is the claim on the actions of bailiffs or false actions of bailiffs. In this case, we call it adverse claims because it was operating back then in 1808. Okay, so first thing about the Code de Procédure Civile. It was granted in 1808 with the special instruction of the Minister of Justice. It was mentioned that it will be in Poland for a very short period of time, like as long as we prepare our new civil procedure code of Polish origins, and it took 60 years, and it wasn't Polish, it was Russian, in 1876, if I remember correct. And of course, when you have material law, like a Napoleonic Code, you need to have the proper civil procedure code. It's like it has to be done not separately, but together along. It's something obvious. So it was it took effect till 1876. So a very, in my opinion, a very long time. Another thing is that my primary legal sources. In Poland, this is another topic. In Poland, almost no one tries to conduct any research on the legal practice. Why? It's not possible. It is extremely hard if you want to do something like that for 19th century or before. Why? Because of the Second World War. Almost all of the archives in Warsaw were intentionally were set in fire. Normally it was 1944, so during Warsaw Uprising, everything was just burned, and the only collection of court records which are, in my opinion, complete, they come from the Trybunał Cywilny Kaliski from Kalisz. It was the town, city in the west side, or just the west territory of the Duchy of Warsaw, and this is like the only collection which survived the war, because during the war it was taken to Poznan and to Germany. So they treated this as their archives. That's why it survived. So everything I prepared is prepared on this special collection, because this was the only way just to say anything about legal practice in Poland. Okay, but speaking of this legal practice, I will say how it looked. It looked in Kalisz, in this tribunal. This was a civil tribunal in Kalisz. It was the second instance in the court's hierarchy. So every case I met there, it was the most substantial case from the second instance. So very often there are just some kind of appellation, and I couldn't find the same case from the first instance. It was just impossible, because there was no records. So first of all, I just went through records from 1808 till 1812-13, when the Duchy of Warsaw was really operating, and it was free, etc., independent. And I was sure that I won't find any too many of enforcement proceedings cases. It appeared that almost 80% or 70% of cases there is enforcement proceedings. So from one problem I found another problem, just too many of them. But that's a good kind of problem. So most of them were just enforcement proceedings, and like 80% of them were connected with the false actions of huissier de justice of bailiff. Okay, and about bailiff, it's like this is interesting because of the fact that the same institution was in Poland and in France, and they were developed in a completely different manner. It is of course something normal, because the problem in Poland was that we didn't have enough lawyers. We didn't have enough law schools. Actually, we had one in Warsaw created in the beginning of the Duchy of Warsaw. We weren't prepared for something like that. Another problem was that the official text of this Code de Procédure, it was French. It wasn't Polish. There was a Polish translation from 1810, but officially it was French, one original authentic text. So the first difference. First of all, our bailiffs weren't prepared for the job they had to do. So it is it is evident because of the fact that, as I said, 70–80% cases were connected with their wrongdoing, negligence, or omissions. This is one thing. Another question is that very often they were undereducated. They were undereducated because they didn't graduate from any school. Later in 1820s, I found there were some bailiffs who graduated from school. From 1811, they had to pass a special test or special exam, state exam, just to operate as officials. But it wasn't. We can't compare it with attorneys or judges or prosecutors. It's just a completely different story. Another thing is that when I tried to find out how it looked in France, for example, the bailiffs, they had a whole organization of bailiffs. From 1820, they even published their own magazine. It's a legal magazine of bailiffs in France. In Poland, it didn't appear. It didn't exist. Anything like that. So there were so many different. And another thing I want to mention is, it's 5 minutes. Sorry. Another thing is this adverse claims within enforcement proceedings. As I said, today we have a special legal instruments, actions just to take by a creditor or debtor during the procedure. Back then there was no institution like that. So if you were just you were unhappy with the verdict or the action of the bailiff, you just had to sue the bailiff, and at the same time you had to sue your creditor or debtor. So debtor had to sue bailiff and creditor, and creditor, bailiff, and debtor. So always all together. And very often it was just the cause. The main cause of this claim, of this adverse claim during the procedure, was the wrongdoing of bailiff. Very often it was, for example, at the time, like the bailiff was too quick, or he didn't take any action for a very long time, and it was I met 4 cases when there was a too long time in the action of bailiff, and it was actually the only one case when the bailiff lost his job. So, like the most severe situation. Another thing are the changes of the civil procedure, because Polish powerful people in 1808, they were sure that they can't change French law. Why? Because as it was said before in the codification era, that they were sure that if there's one codification, it is complete, it is precise, and this is something what we can't change because this is ideal. Because there are some ideas of the people who created it, and we can't change it. Especially in situation of Polish people, because they couldn't change it because they didn't feel that they have this power. But of course, in the enforcement proceedings, they need to do that, and they were changing it in different way, in different manner than French people changing it. And for example, in 1823. They changed it completely by derogating the most important institution, sale by auction. So it was just completely derogated. Like now, it's something that the most popular form of execution from immovable goods, and it was the step back to the Polish traditional law. Okay, so thank you for your attention.